Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, and today's video is about transgender rights in Texas under employment law. Here in Texas, there aren't a lot of great protections for transgender rights in the workplace, and certainly it depends upon what part of Texas you live in, whether, or more specifically where you work, that will determine what kind of protections you have for your job from transgender discrimination. Of course, like everybody else, there are certain protections that apply across the board to everybody, but when we deal with issues involving gender identity and transgenderism, we're dealing with a specific issue, and there can be some forms of discrimination particular to the transgender status, along with issues of gender identity, sexual orientation, and other related issues. So we'll talk about some of the protections that exist on the federal level, on the state level, and on the local level that invoke transgender rights under employment law, and how transgender discrimination affects the workplace. So looking at federal law, historically there's been no explicit protection for transgenders or transgender status under federal law. Some enterprising employment attorneys figured out that they could view Title VII of the Civil Rights Act of 1964, which prohibits sex-based discrimination, and assert a claim that discriminating against an employee on the basis of their gender identity or sexual identity in the workplace would be a form of sex discrimination. That went all the way up to the United States Supreme Court, who agreed that it is unlawful to discriminate against somebody on the basis of their appearance as it relates to their gender identity. Now, it's important to understand that these cases do not deal specifically with a transgender status or somebody who is transitioning within the workplace or while they're working at a particular place. These cases actually deal with gender stereotypes. So it prohibits employers from discriminating against a woman who has a masculine appearance or doesn't dress in an overly feminine way, or on the other hand, a man who maybe has a more feminine appearance or way of dressing. That doesn't particularly apply to people who have transitioned or are transitioning and dress in a way that is different from their anatomical birth status. However, the courts have generally agreed that transgender status, that idea that you're not, that your appearance doesn't match your anatomical birth status, does implicate these sex stereotypes or gender stereotypes. And from that regard, there have been some cases supporting these arguments that transgender status is protected when these sex stereotypes are involved. Currently, the Equal Employment Opportunity Commission is engaging in some cases where they're trying to make this position more specific and get the courts to agree very clearly that sex discrimination directly implicates this transgender discrimination on the basis of appearance, and really try to push that argument a little beyond just the gender stereotypes, but to explicitly say that when somebody is being discriminated against on the basis of their transition or their path of transitioning, that this is by itself sex discrimination, and uncouple it from having to rely upon this more narrow gender stereotype kind of argument. Right now, the EEOC is having some moderate success with these arguments. It's a process that they're still working through, and they'll probably continue to work on it for several years. Now, it's important to point out as well that because these cases rely upon the gender stereotype, it's really just the question of this person was, say, born a man and appears at work as a woman, and that's why you're being discriminated against. Title VII does not prevent discrimination on the basis of sexual orientation. So in that same situation where we have a male to female transition, if the employer or management is discriminating against this individual because they know for some reason that this person was born anatomically male and has an attraction to other men, if that's the basis of the discrimination, that itself is not protected by Title VII. And even if the EEOC is successful with these cases in broadening the protection for transgender rights and prohibiting transgender discrimination, it won't have any effect on that sexual orientation. There are some other laws that we can talk about that are implicated there, but on a federal level, the best we get is really discrimination purely based upon the physical or visual appearance of the person, or the way that they behave, or the way that they act as an employee. That usually will fit into these gender identity arguments, but if sexual orientation becomes an issue, that's kind of out of bounds. Looking at the state law in Texas follows federal law fairly closely on these issues. Personally, I'm not too familiar with any cases that deal with that fit this transgender discrimination into the gender identity argument exclusively based upon state law. But of course, in such a situation where a lawsuit is being brought, it would be expected to see claims brought under both federal and state law. So from there, we would expect state law to follow federal law, at least as far as the gender stereotype. We may have to see some state activity to get our Texas courts to acknowledge transgender discrimination as an individual type of sex discrimination under the Texas Labor Code. There is some movement on the federal level of trying to introduce some legislation to prohibit sexual orientation discrimination in the workplace, but at the state level, we're just not there yet. And given the attitudes of our governor and attorney general, I don't expect that's going to be something that we'll see in the near future. So to sort of tie that together, as far as state law goes, no special protections. At best, we're going to fit that same sort of gender stereotyping argument onto the Texas Labor Code that we use at the federal level. Where things get interesting in Texas, though, is when we start looking at local laws. And it's not very common that we look at local laws to create claims and lawsuits. But there are a few powerful claims that can be located in local law if you go looking for them. The problem with looking at local laws is that it's a real patchwork. Each city has to enact its own special laws that apply to the city and end at the city borders. So some cities are going to be more liberal about this idea than others. And so what we find across Texas is a lack of uniformity in laws protecting transgender employees from discrimination on that basis. It's going to be most common within the larger cities and less common in the smaller cities. And that can be a real problem, actually, in larger metropolitan areas, like especially Dallas and Fort Worth, where a lot of employers have located their offices in either the suburbs or some of the more outlying urban areas. So Fort Worth and Dallas both have some laws that we'll talk about, but if your office is if your work site is located outside of the main city and you're, say, across the street in one of the suburbs, you may not find these laws applicable to your workplace, and that can sort of leave you hanging without a direct remedy. But where we do find these local laws that have enacted protections against transgender discrimination in the workplace, they are actually very effective opportunities to bring claims that are specific to transgender issues within the workplace. We find these laws in virtually all of the large cities in Texas now, but like I said, plenty of small cities and suburbs surrounding the large cities have yet to take in this step. It's also common, along with these laws, to see specific prohibitions on sexual orientation discrimination. And although sexual orientation is not always coupled specifically with transgender issues, often from the perspective of somebody discriminating against an employee, these two things are closely related. And so there may be claims available under both issues that can be brought under these local laws. Excuse me. As far as the local law goes, it's important to look at the specific law, the specific city where you live, where you work. It doesn't matter where you live. Wherever the workplace is located, wherever you perform your work, that's what's going to govern whether there's a local law that might prohibit that transgender discrimination in the workplace. If you work in multiple different offices, it becomes a little more complex, especially if some of those cities where you work have these protections and some of them don't, because we've got to figure out where did certain activities occur and whether these different cities really apply when it comes to bringing a claim. But if there is a city law that prohibits transgender discrimination in the workplace, we can bring those claims in state court under that local law, even if federal or statewide law would not support that claim. The hope is more of at least the suburbs surrounding the large cities will enact these ordinances. But for now, it doesn't seem like there's a huge movement to do that, but something to look forward to in the future and something to work towards in the future. So let's kind of summarize that together. Federal and state law, same thing. We've got to fit transgender discrimination into these sex or gender identity stereotype kind of claims at the local law. If there's a law that applies to your workplace, we can use that to bring a claim of transgender discrimination if your workplace is located in a city where there is no such prohibition in city law. Then we've got to rely on what we get from federal or state law. If you believe that you have been discriminated against or you are being discriminated against on the basis of your transgenderism or your transition, it's important that you talk to an employment attorney quickly. Bringing claims forward under any of these laws requires you to first file an administrative complaint with a particular agency. The EEOC handles these claims on the federal level. The Texas Workforce Commission has a civil rights division that handles these claims on the state level. And at the local level, it's a little trickier. There's usually some hidden department within city government that accepts these claims. And you've got to make sure that these claims are filed with the right information within a very limited window of time so that an investigation can occur and then that agency can forward to any other agency that might be involved, let them have their investigation, and then you can move forward with a lawsuit if it comes to that point. But if you don't file that complaint with the right agency within the right time, with the right information, it doesn't really matter how bad the conduct has been at the workplace. You've lost the right to bring those claims forward, at least as far as anything that's occurred too far into the past for whatever that time frame is. So it's really important to work with an employment attorney early on, make sure that that complaint gets filed in the right way, in the right time, so you can preserve any claims that you have, or just to be able to move forward with some sort of formal mediation process to try to resolve it, even if you're not looking to try to file a suit or collect any kind of money for what's happened to you, even if you are entitled to it. So my advice is always, if you feel like you've been discriminated against in the workplace, talk to an employment attorney as quick as possible, and let that attorney assess your claims and help you work out a strategy on how to move forward. So that's pretty much it for today's video. Thanks for listening. Sorry I feel sort of rambling today. I'll try to be more clear and less rambling next time. So again, thanks for listening, and I'll see you next time.